us. It's really just so wonderful to see a crowded room wanting to hear about these issues. I'm Jasmine Coley. I am the Executive Director of the Critical Race Studies Program. I think I know a lot of you. Some of you I don't, and some of you especially one of us who are interested in joining Critical Race Studies. Feel free to reach out to me, shoot me an email. I have office hours, or I can always schedule meetings outside of office hours with any of you who are interested in thinking through any of these issues. So this event, Critical Perspectives on Race and the Law, we generally have an event like this at the beginning of the year, most years, just to discuss the developments in race and law. And this year, there's a lot. So I have no idea we were talking about this, and we know that a lunchtime discussion cannot do this adequate service, but at least to hear a little bit from our faculty and their analysis regarding what's going on, we thought that would be helpful. A couple of things. First, Professor Baldwin, who was supposed to be on the panel, unfortunately is not feeling well, is not able to attend, and she sends her regrets. But to hear from her and a lot of our other faculty, hopefully you have all seen, and I will send again, the registration for our upcoming CRS 25th anniversary symposium and celebration. So that's going to be... We will also be sending out a form for volunteers, because really this is a community event and we need all of you and your support also. So I hope you will fill that out. And it's going to be an incredible event over 3 days. A lot of our faculty will be on panels, plus we will be having so many people from around the country and, knock on wood, around the world, although a lot of people are having visa issues, unfortunately. We're going to have over 130 panelists, speakers who are coming, over 4 plenary panels and 27 concurrent sessions. So there's going to be so many incredible conversations. If you haven't had a chance yet to look at the website and look at the agenda, I really urge you to do that, because I know I can't wait, because I know that we really need to be having these conversations. So anyway, with that, I want to turn it over to our wonderful faculty. Professor Arnold, who teaches civil procedure and fed courts, who I think some of you might have in your class, or have us. Yes, okay. We'll be moderating, and we have Professor Harris and Professor Arulanantham, who will be our panelists. And I was going to try to give their bios, but they're so lengthy that I can't even start. We'd rather be hearing from them, so you can look that up online and take classes with all of them. And with that, I will turn it over.
Let's see. Oh, great. It's great to see you all. Thank you so much for coming to this really important event. A few weeks ago, we had our CRS welcome dinner, and many of you were there. And I think one thing that came out of the dinner and the conversation was how important it is to think through these pressing issues on the relationship between race and the law together as a community. And I'm thrilled to see how many of you came out to think through these issues together as a community. So thank you for being here. We are thrilled. I'm thrilled personally, and I'm sure you all are too, to have Professor Arulanantham and Professor Harris here to guide us through the discussion. As you all know, their bios are too long to summarize briefly, but Professor Harris is one of the foundational thinkers in this entire field. And Professor Arulanantham is not only an expert in immigration law, a fantastic doctrinal scholar, but also one of the most active litigators in this present moment. So this is a real treat today. So the order of events, Professor Arulanantham will be speaking for about 15 minutes on some issues related to immigration litigation. Now, then we'll turn it over to Professor Harris, who will be discussing issues including dynamics in constitutional law and how CRT and CRS might respond. Then we'll have a brief discussion here on the panel, and then we'll open it up to questions. We genuinely want to hear your questions and look forward to an exciting discussion. So I'm going to pass it over.
Yeah, great. Thank you, Alex, and thanks all of you for coming. As Alex had said, I've been doing a lot of active litigation lately. For basically the last year, I've been more or less litigating full-time on immigrants' rights issues, and he asked me to try and give kind of a lay of the land of what's happening with some of the prominent immigrants' rights litigation that's going on around the country. So I'm going to start with that, with just kind of an overview of some of the cases that have gotten a lot of attention, and then I'm going to do a deep dive into one of them, which is a case that I've been working on a ton, including up until just right before this panel, in fact. So let's see if it works. So far, no luck. No, it did work. No, it didn't. It was finicky for us earlier.
Bring the keyboard. That's the...
You can advance them too if you want to. I don't mind that. There's not that many. Voila. Yay, thank you. So I think, to me, the most striking feature of what has been happening from a litigator's perspective is that the administration has engaged in a remarkable war on the rights of immigrants, something beyond what I think I've seen probably since 9/11 and maybe even before then. So it's just an extraordinary set of attacks. And lower courts have been quite robust in pushing back against that in response to a lot of litigation that had happened, been brought by a number of people in the immigrants' rights movement. And the Supreme Court, after some initial pushback, has been extremely deferential to the government. And I think it's just briefly here at the outset, I wanted to kind of run through that to give you a sense of it. So the first case on the left, Trump v. JGG, arose out of the administration's invocation of the Alien Enemy Act as a justification to round up and try to summarily jail and then deport. And I say deport, it's not really necessarily the right word, to send to a prison in El Salvador several hundred Venezuelan refugees. And this came out of the, not entirely out of the blue, in the sense that the administration had talked about how they wanted to invoke the Alien Enemies Act. Stephen Miller had said it. It was in the New York Times. It was kind of in some of the playbook stuff that they had done. So people in the immigrants' rights world and others knew that this was coming. But the actual announcement happened only after they had already arrested all these people, and they were truly trying to get them out of the country before there was any kind of judicial review of it. I actually ended up with other attorneys at the Center for Immigration Law and Policy here representing 3 people who were caught up in that. And it was this insane, Friday night to Saturday night kind of thing where we managed to get temporary restraining orders from federal district courts in Texas, conservative district courts in the Southern District of Texas, to stop those particular deportations. There was other litigation that stopped a handful of them, but a huge number of people were actually deported before the court orders were sort of acknowledged. And there was a big fight over whether or not the government had complied with the court orders that played out. I'm sure a lot of you would have seen this. There was a lot of coverage of this about whether the government had actually just simply ignored a court order which had required them to turn the planes around, because by the time this happened, by the time the court order came, there were a lot of people loaded up on flights. Subsequent to that, the court order barred those flights from occurring, but it was the Supreme Court said, this is I think important thing to understand legally, when the issue got to the Supreme Court very, very fast, the Supreme Court said 2 things. The thing that it's been sort of known for was they said, the Due Process Clause requires that these people have a chance to challenge their detention and summary deportation in court. And people hailed that as a victory. And it was, I suppose, if if the bottom drops low enough, like, that's an important victory. They can't summarily jail you without you having a chance to ask whether or not that's lawful. But the court also said this case should not be brought in one national case. Instead, it has to be brought district by district. In other words, if you want to challenge this and you're detained in the Southern District of Texas, you have to file a lawsuit in the Southern District of Texas. If you're in the Western District of Pennsylvania, you have to file in the Western District of Pennsylvania, Southern District of Georgia, Southern District of Georgia, on and on and on, right? And so the effect of this is that it kind of decentralizes, disperses all the litigation, and then requires detained people, this thing's going in and out, requires detained people to get lawyers in order to file these kinds of petitions, right? So that is also a move that the Supreme Court did in the same first case. And then what happened right after it, in AARP, the government took a bunch of these people who they now couldn't deport out of the Southern District of Texas because the court order had barred that, and rounded up, did another roundup, and sent a bunch of people to the Northern District of Texas, and literally tried to do exactly the same thing that they had done the first time, except out of a different judicial district. And I'm sorry, I could... You want to try this? Yeah, or I can also just... Can you guys hear me? Yeah, I'm good. Good.
Sure.
Yeah. So then they tried to do the same thing out of the Northern District of Texas, and that led to another round of insane emergency litigation over the course of, into the wee hours of a Friday night and a Saturday morning. And the ACLU national class action litigators who were doing the first case were involved in this one, along with a bunch of other people who were hearing about their Venezuelan clients getting picked up. In that case, AARP, the Supreme Court, stopped it and said, don't do that, don't take any flights. Honestly, I think that might be the only single, entirely unambiguous victory that has happened in the immigrants' rights movement that the Supreme Court has given people in the immigrants' rights movement in this entire period, the last 9 months. And they said, you cannot do that. We already said you couldn't do this, and you cannot do it. And so that sort of stopped the use of the Alien Enemy Act to cause these immediate summary deportations. The litigation on it is continuing. It's still happening, but that summary thing was stopped. The next one on there is Noam v. Abrego Garcia, which I'm sure a lot of people would have read about. That was a case where somebody actually had an order already from an immigration judge that said they could not be deported to El Salvador, and the government made a mistake and arrested them and sent them there anyway. And they won an order from the Supreme Court saying that you have to facilitate the return of this person. And in the interest of time, I won't tell you the whole story about it, but this is somebody who had won an argument that they would face persecution or torture if sent to El Salvador, and it was won and final, and the case was over. And anyway, the person got arrested and was sent to El Salvador. And what followed was this very strange situation where the government first said, hey, all we have to do is facilitate his return. And we have done that because if he comes to the U.S. border, we'll let him in. We might detain him, but we'll let him in. And that counts as facilitating his return. And of course, this seemed very disingenuous because everybody knew that the reason why he was being held in El Salvador was because the U.S. government had arranged for El Salvador to hold all these people, like the Venezuelans I was talking about in the earlier case, right? And so I think there was this real sense that perhaps the court was, the government was defying the court. And I think there was definitely some fear that, wow, like maybe the government's like, we don't care, you say facilitate, we think that means whatever, we want it to mean. That played out then in lower court litigation over sanctions, because the lawyers for Abrego Garcia tried to argue that the government was in contempt of court and violating that order, and there was this odd legal political standoff, and ultimately then the government purported to, they charged him with a crime, totally preposterous, based on some things that had happened long ago when he was arrested in a car that, they say he was smuggling non-citizens, but he wasn't arrested for it. This is years ago. And on that basis, they charged him and brought him back. So they did comply with the court order in this very weird way. He's now out. He's out on bond. That case is pending. That was the last time anybody in any immigrants' rights case won anything of significance from the Supreme Court. And there's now been, 5 I listed here. And this is not only, these are the immigrants' rights cases, but similarly, I think it's 18 now or something like that, 18 consecutive what they call shadow docket orders, like orders where the government has lost in the lower court and has gone to seek relief from the Supreme Court. The Supreme Court has granted it on all kinds of issues: federal firings, grant money to fund research, like all foreign aid, like all kinds of stuff. And so the immigration cases have been definitely caught in the kind of buzzsaw of this. I'll quickly run through this, and then I'm going to do a slightly deeper dive on one of them. The first one, NOM, the National TPS Alliance, is actually my case. I've spent most of my life in the last 6 months litigating this. It's a case to protect people who have something called temporary protected status, which I'll talk about in a minute. It's a form of refugee protection that more than 1 million people in the country currently have, and the administration is trying to just end it. The next one is a similar case for something called parole. It's slightly smaller, about 500,000 people. It's a slightly shorter form of protection, but it was another form of protection that had been made available in the Biden administration and covered people from Cuba, Haiti, Nicaragua, and Venezuela, from those 4 countries. The next one, DHS-DVD, is a case about what they call third country removals. It's just a concept that people who have been ordered deported, if their country won't take them back, can they be sent to just like any other country, like Sudan or Rwanda, even if you're Mexican or Vietnamese, for example? And the government has been doing this, and under these arrangements, which are similar to the Salvadoran, the Salvadoran one I mentioned earlier, they're sending them to prisons in those places under these arrangements. So this was a challenge to that, okay? What all of those have in common, in all 3 of those cases, district courts and then circuit courts ruled that the government's policies were unlawful. They went to the Supreme Court, and the Supreme Court stayed it. They said, no, we think it's fine, except even that description is not accurate, because when I say they said, no, we think it's fine, that is actually more reasoning than the court actually provided in any of these cases. They literally say, the order is stayed, and then blah, 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 procedural garbage. And I'll show you one of these in a minute. So it's striking, right? And the result of these was that more than 1 million people, between all of them, 1.1 million people were stripped of their immigration status and lost the right to work in this country, and many of them, thousands of them, were detained and deported as a result. And the Supreme Court authorized this after courts had explained why it was illegal. Striking development. The last 2 I'll just mention briefly. Trump v. Casa is the birthright citizenship case. I'm guessing all of you already kind of know about that. That seemed like a perfect candidate for a situation where the Supreme Court would either just allow, the lower court said it was illegal to end birthright citizenship. It's in the Constitution. There's nothing ambiguous about it. The government went and said, we want you to stay that and allow us to implement this. And instead of doing that, the Supreme Court didn't say, okay, fine, you can allow birthright citizenship and they also didn't say the opposite, like, oh, clearly birthright citizenship is in the Constitution, you can't do it. Instead, they used the case to do some very different thing, ending universal injunctions, okay, which I won't get to in detail, but they turned it into this case about an odd procedural mechanism that, again, had the effect of splintering some of the litigation. Okay, now quickly, people won again the protection against in favor of birthright citizenship in the lower court, so birthright citizenship remains intact and it's fine. But it's again telling, like, this is a thing where surely you might expect a court to say that you can't do that, and they didn't do that. Instead, they talked about some completely different thing. And the last one I know we'll talk about more, but the last one is the Raids case from Los Angeles, known the Vasquez Perdomo, and that, of course, is a case where the Department of Homeland Security was engaged in obvious racial profiling, running sweeps all throughout Southern California, arresting and detaining, and then actually also arresting people, clearly in part on the basis of race. Very detailed district court order said it was unlawful. Very detailed circuit court opinion affirming that for the most part, and the Supreme Court stayed it with no explanation. There's a concurrence from Justice Kavanaugh, which we'll talk about kind of later. So that's sort of lay of the land. I could stop there. You want me to do a deeper dive into TPS now, or do a little deeper dive? All right. Do you want to advance then? So, temporary protected status is a form of refugee protection that has existed since 1990, under which if a country is not safe to accept the return of its nationals, the Homeland Security Secretary can designate the country, And once that happens, all the people from that country who are living here get the right to live here, free from fear of detention and deportation, and the right to work here, provided basically that they have no criminal history. If you have even 2 misdemeanors, you're not eligible for this. That's the law kind of in a nutshell. It's been used by administrations of both parties since its inception, and really was uncontroversial and the subject of very, very little litigation until 2016, when the Trump administration really went to war on it. That happened. I actually was very involved in that litigation. We'll sort of skip over it for the time being. In 2020, when the Biden administration came, they used this as a tool to help to provide immigration status to the really several million refugees who came to this country, including 600,000 from Venezuela, about 500,000 from Haiti. Those are the 2 groups that mentioned in the slides. They're the biggest groups, but also people from Nicaragua, El Salvador, Honduras, Sudan, Burma, and there's 16 countries that had Cameroon, 16 countries that had TPS grants. It was a mechanism that the administration used to try and protect a lot of people. Trump administration hated this. Trump campaigned on it, vociferously opposing it. You want to flip over? Let's see if it'll do this for you. And I wanted to put these up. Can you guys read those? You can see it? I wanted to put these up. I feel like for people who do race discrimination, but are not like deep in the weeds of immigration, it's really mind-boggling to look at the things that the president is actually saying, and saying specifically about Venezuela, right? And these are statements that were made specifically about Venezuelans and even Venezuelan TPS holders, right? This claim Trump started saying on the campaign trail that Venezuela was emptying its prisons and jails and mental institutions and sending people here. And he was drawing this connection. This is like to poison the blood of the country. And he actually said this. And this is the rhetoric used by Hitler in the 30s. It's also, actually Hitler got it in a way, from rhetoric used in the 20s in the United States by eugenicists to justify the creation of some of the most restrictive immigration policies that ever existed in the history of the United States. And Trump is using the same rhetoric. By the way, this is what happens when you do litigation. We actually went and had people study like the population of Venezuela's prisons and mental institutions, and it's totally false. There is no massive drop. There's no like people being emptied out. This is what you have to do because courts are supposed to be about facts, right? But nonetheless, when the Secretary of Homeland Security announced the termination of TPS for Venezuela, right, so they ended the temporary protected status programs, tried to do this, she said, the TPP program, TPP, they don't have to get their facts as well as we do, but for you all as law students, you know it's TPS, not TPP. The TPP program has been abused, and remember, this is what she said on national TV to explain the decision the day after she had made it. And remember, Venezuela purposely emptied their prisons, emptied out their health facilities, and sent them to the United States, so we are ending that extension of that program. I have to tell you, you could do years of race discrimination litigation. You will rarely get a piece of evidence that good. There's the reason I am doing this thing is because of this crazy racist view that I hold, right? Which dates all the way back literally to eugenicists from the 1920s, right? So people sued over it. You want to advance the next one? I think you should advance it again. Sorry. And, we won at first a very, very good order from the district court in San Francisco saying that it is evident that the secretary has made sweeping negative generalizations about TPS beneficiaries in toto and taking en masse actions against all Venezuelans based on the alleged bad things done by a few and acting on the basis of a negative group stereotype and generalizing such stereotype to the entire group is the classic example of racism, right? And I say this to connect to what I was saying at the start, right? It's not like courts are sitting there washing their hands. A court said this is racist, very, very clearly. You want to advance again? And cited then, I won't bother to read the whole thing to you, but cited the Korematsu dissent, and cited also the Hirabayashi decision, saying hey, the dissent is saying we're descending into the ugly abyss of racism. We need to stop that. I mean, that's what's going on here. This, by the way, Asian American judge drawing this connection very, very tightly. So it's a very powerful decision. One more. We also sued the Trump administration, by the way, going to war against all the TPS countries. So they also tried to end it for Honduras, Nicaragua, and Nepal. That happened just a few months after the Venezuela one. The group I represent, the National TPS Alliance, we sued over this as well. This order also is filled with all kinds of racist invective, or the history of it, and in particular the reference to invasion. They cite in the order terminating TPS that we're doing this because we have to stop the invasion, referencing back to the president's executive orders about an invasion. And invasion has a very similar history to poisoning the blood. It goes right back. It's like tied to Great Replacement theory. These ideas that people from shithole countries will come and replace all the better stock European descended people in the country. And here, this is actually a different judge, African-American woman, former public defender, superb opinion, again, very carefully, a little bit harsher, I think, in some ways than the first one, but just as like, what the government is asking these people to do is to atone for their race, leave because of their names, and purify their blood. This powerful rhetoric, again, stopping the order. And what happened? You get this. And this, by the way, the first order, 78 pages, the Venezuela decision, very carefully, right? I just read you that one little bit, right? It's super detailed. This is the entirety of the Supreme Court order striking it, putting it on pause, that allowed the termination to go into effect for, like I said, 600,000 Venezuelan TPS holders. And as you can see, even this makes it seem more detailed than it is, because this is mostly all procedural stuff. It's like, this is the timing for when the stay goes into effect, and this is how you get rid of it. There's no reasoning in this order. It's bonkers, right? And this is what they've done in our case, and the same thing in Svetlana Doe, same thing in the other ones that I mentioned on that slide. So I was going to stop. Maybe I will stop here and then come back, because I feel like definitely want to hear from you, talk about the raids on the next go-around, if that's okay. I don't know, it's up to you.
Well, only because I had something I was going to tie into the raids, so maybe if you could just
do a little bit? Okay.
And then we can come back to it in more detail.
Okay. So actually, advance over that then, if you don't mind. Thank you, by the way. I really appreciate that. So, I'll just briefly, go forward, like another one. Yeah, go back. So, in the raids case, the same thing happened as well. Like I said, very good district court order. The raids case is Vasquez Perdomo, okay? A very good district court order saying this is unlawful. The Fourth Amendment requires individualized suspicion, which means when you stop somebody, you have to have at least a reason to believe that that person is unlawfully present in the country before you detain them. You don't get to detain them and then ask and figure it out, because this is not supposed to be a show me your papers kind of country. And in particular, surely it cannot be that you can use race as the basis, or even a basis, to stop a person, you would think, right? But, and that's what the district court found, that is exactly what they're doing. They're using race along with whether or not people speak Spanish or speak English with an accent, where they are working, and where they are. Like they're at a bus stop. Vasquez Perdomo was arrested at a bus stop. And they're like, oh, undocumented people are more likely to be at the bus stop, so let's just arrest everybody at the bus stop, and some of them, might be unlawfully present. And what the court said is that's not how the Fourth Amendment works, because you have to have individualized suspicion about somebody before you can deprive them of their liberty, before you can restrain them, right? Stay there. So the Supreme Court reversed this. There is no explanation. The actual order, the governing order, has no reasoning in it. But because by the time this happened, they had gotten a lot of flack, a lot of people criticizing them, including federal courts and all sorts of people saying, like, this unreasoned decision-making is not good. You really should not be doing that. Justice Kavanaugh wrote a concurrence that gave his reasons for doing it, and it's really horrific. And what it says, I mean, you can see it here. He says, to stop an individual for brief questioning, the government has to have reasonable suspicion that they're illegally present in the United States. That much, that's the pre-existing doctrine, right?
Apparent ethnicity alone cannot furnish reasonable suspicion, but, however, it can be a relevant factor when considered along with other salient factors. So you can use race as part of the justification. And then he talks about some examples, like, hey, like, obviously, there are probably a lot of undocumented people working in car washes. Leaving aside that there's, like, citizen plaintiffs in the case who are in the car washes who get repeatedly arrested. And it's like, so, therefore, it should be okay. You want to advance now? And the things, we'll come back to in more detail, but the thing that struck me most is the Ninth Circuit had said this was unlawful 25 years ago. 25 years ago, they said, it makes no sense to say that Latino people or people speaking Spanish are, for that reason, more likely to be undocumented, because look at the demographics of Southern California, or actually they were talking about even the border region. And that evidence, by the way, was in the district court record in Vasquez-Perdomo. 47% of the people in the Central District of California self-identify as Latino or Hispanic or of Hispanic heritage. 35% speak Spanish in the home. You know, which doesn't mean they don't speak English also, obviously. I'm sure all of you know that, but might well speak Spanish in any interaction. It can't be that those are valid bases for detaining somebody, but yet that's what this concurrence suggests, that it can be part of reason. So the point I'm making is, like, 25 years ago, the Ninth Circuit had said the opposite, but here today we are, you know. And then last one, and I just put this here because it was just the striking contradiction. This is the case that ended affirmative action in university admissions, probably, or at least a lot. And there's no citation to this in Vasquez-Perdomo, but Justice Kavanaugh signed this opinion, and of course the majority of the Supreme Court wrote it, and it's such beautiful soaring rhetoric. You know, eliminating racial discrimination means eliminating all of it, because the Equal Protection Clause applies without regard to any differences of race or color. It can't mean one thing applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, it's not equal. And this is the rationale for killing off diversity in university admissions, but is nowhere to be found when the court blesses massive racial profiling on the streets of our city. So that's where we are. It's not a great spot, but I'll stop there for the moment.
Thank you. That was a masterful overview of a huge amount of doctrine and litigation. I'm actually coming at this from a somewhat different angle, and part of it has to do with, I think, the ongoing sort of shifts in constitutional law more generally, but what I would argue is part of what I think critical race theory can bring to the conversation. And part of what I want to say is really that the project of critical race theory has always been to try to analyze and assess current conditions. What I mean by that is to say that theory is an analytical tool that helps us assess current conditions. Theory does not always lay out a pathway for the way out, but of course the first step is you got to know where you are. And so part of what I think critical race theory brings today is an understanding of a couple of important points. One is that it began as a project which was a critique that brought up the contradiction that Ahilan just ended with. That is to say, the erosion of the rule of law, a kind of racial exception to the rule of law. The way in which the rule of law, by the way, not to presume that we all understand or have the same understanding, but sort of the basic principle that no one is above the law, all are equal above the law. This is sort of core rule of law principle. Another core rule of law principle is notice and an opportunity to be heard. This has been the feature of the legal order in terms of its self-presentation from the beginning. That is, this is a nation of laws, not men. All men are subject to the law. I'm saying men deliberately. And the point that I'm trying to make here is that what critical race theory, as well as its antecedents, because I don't want to say that this project began this idea, but was to point out the contradiction between the operation of the rule of law when it came to racially subordinated populations. When it came to racially subordinated populations, there was a different set of rules. And we can start with the absolute foundational architecture. 3/5 clause is a carve-out a racial exception to the rule of law. We start out with the racial naturalization process. That is to say, one could not be naturalized, and this goes back to the 1790s, you could not be a naturalized citizen unless you were white. So we start out with a carve-out right away from the rule of law. Now, in important ways, I think, we can go through history and talk about this bit by bit. Citizenship, of course, excluded on the basis of race under Dred Scott. And we have the immigration system as a form of racial ordering. We also have, in terms of the rules of property, a kind of racial carve-out. Indigenous forms of possession are not considered property. So there are many ways in which the foundational rules set up this way in which racially subordinated people stand outside the rule of law. And this is the tradition that critical race theory was building on, was to call this out. Now, why does this matter? Because we are now in a moment where the exception is becoming the rule. That is to say, you cannot erode the rule of law with respect to one population and not have it bleed into the entire system. And one of the principal ways in which this comes about is the use of law itself to legitimate lawlessness. What Ahilan just described, which is in each of these cases, particularly in Vasquez Perdomo and in the birthright citizenship case, is a formal kind of recognition of the rule of law. So let's take the equal protection, the birthright citizenship case. I'm kind of jumping around here. Let me go back. The historical sort of exclusion, the de jure exclusion, is purportedly attacked by and disrupted by the Civil War. The Civil War is a revolutionary moment. It's a moment in which the actual foundations of the system are actually challenged to its core, because enslavement is built into the system. The challenge to slavery actually shattered the agreement regarding the whole system. And that division, of course, is in place from the beginning. It just matures and to the point of its eruption in the Civil War. You have then the reform. So this is Kim Crenshaw's Race, Reform, and Retrenchment. You have then the reform moment of Reconstruction. Reconstruction is a radical idea and allows for the adoption of the Civil War amendments, including the 14th Amendment, which overrules Dred Scott. The 14th Amendment says African descent, the people of African descent are citizens of the United States if they are born here, right? And so birthright citizenship is tied up right at the beginning with trying to correct this racial exception. It then leads to a period of retrenchment. That is, immediately after Reconstruction, we have the period of the so-called redemption, where the court, through a series of cases, essentially eviscerates the 14th Amendment. And that's not just me talking. That's actually a relatively conservative judge in one of the early affirmative action cases called Bakke. Justice Powell says this is a period where the court strangled the meaning of the 14th Amendment equal protection guarantee in its infancy. So there's a sort of historical recognition that this period of redemption gutted the amendments and leaves them sort of in tatters, not, however, completely, because they get mobilized by corporations. That's a whole nother story. But with respect to their initial target, right, their initial reason, the reason in which they are initially passed, people are once again consigned to a racial exception. So you have the period of de jure segregation, which then leads to the period of the Civil Rights era, what's sometimes called the Second Reconstruction. This is the period of Brown and its progeny, and the push for the Voting Rights Act, the Civil Rights Act of 1964. These are all the products of a social movement that pushes for certain kinds of corrections, again, to the racial exception. Where we are now, where are we now if we're trying to assess conditions now? Well, we're in a part of a historical cycle that would generally be called retrenchment, I think, without a lot of contest. Maybe more contested, however, and I want to make this case. We're also in a period of a move to fascism. Fascism is a highly contested set of arguments. I was trying to look up some more of it. I've been trying to read on it, and everybody's got their theory about what the criteria are. Why is this important? Well, again, it's important to sort of know where we are, right? But one of the sources that I ended up drawing on in trying to think about this is from Aimé Césaire, who was a poet and a politician from Martinique, who wrote a very powerful essay in 1950 called Discourse on Colonialism. Martinique was a colony of the French. The French were exceptionally brutal in the Caribbean and in Africa as well. And he was a big critic of colonialism. His argument was that while the West had made a claim to civilization, the high civilization of the Renaissance and all the rest, that was actually on the backs of a set of brutal, dehumanizing processes that were occurring in other parts of the world. So that the colonization and civilization, or colonialism, not colonization, colonialism and the claim to Western civilization were not sort of contradictory developments, but were actually developments that were occurring in the same historical moment. And so by 1950, we've already had Benito Mussolini in Italy laying claim to fascism as a kind of ideology, as an idea. And what Césaire says in this article is basically that what Nazism is the return of the practices of colonialism to Europe. That essentially the same brutal techniques that were used against people, colonized people, across Africa, across Latin America, across other parts of the world, had actually created the conditions in which it then had begun to ooze, he says, to trickle back, to sort of backwash, if it will, into Europe itself. So he says, just to read it in its terms, he says, we must show that each time a head is cut off, he's a poet, he's trying to make us see it, okay? We must show that each time a head is cut off or an eye put out in Vietnam and in France, they accept that fact. Each time a little girl is raped and in France, they accept that fact. Each time a Madagascan is tortured and in France, they accept that fact. Civilization acquires another dead weight. A universal regression takes place, and a gangrene sets in, and a center of infection begins to spread. It's a horrific image, but what he's trying to get us to understand is the relationship between these things. And so for him, the manifestation of fascism in the 30s and 40s that led up to World War II was actually deeply connected to the practices of the racial exception. And what I want to make the argument here today is that we don't arrive here at this moment. This is an exceptional moment, but I don't think we arrive here at this moment without there being some precursors here. And this precursor is what I'm describing. So how do we get to the point where the court can say in how do we get to the point where the court can say in this case that race cannot be considered as a factor at all? Not a determinative factor, just at all, in a holistic evaluation of someone's admissions application. How do we get there? While simultaneously, in Nome versus Vasquez-Perdomo, affirming the use of race as a criterion. How does this happen, and how does this not get, obviously a contradiction? First of all, this contradiction isn't new. I'm not claiming prescience, but my former colleague, beloved colleague, Devin Carbado, and I wrote a piece in 2011 called Undocumented Criminal Procedure, in which we were talking about the ways in which the authorization of abusive techniques in the immigration arena was actually shaping Fourth Amendment doctrine more broadly. So immigration being regulated under the plenary power and this is sits in a box that has sometimes actually been insulated from equal protection and other kinds of norms. But it really isn't, which was the point of our essay. The point of our essay was to say that actually what's happening over there in that box, in that container, is seeping out. It is in fact justifying the use of abusive forms of police interrogation, not interrogation, but police investigation and enforcement that are bleeding into the general practice. So we were writing then at a time when Brignoni-Ponce, the case that Kavanaugh relies on, was really under critique. And one of the criticisms that we got from the article was that we were treating Brignoni-Ponce as though it was still good law, right? As though it had not sort of gotten overripe and people sort of stepping back from it and qualifying it, or the Ninth Circuit later, subsequent to, I think, our essay, actually explicitly saying it's no longer good law. It's good law as of now, right? And I don't mean good in the sense of good, but I'm saying it can be cited without there being any asterisk that says questioned, right? And so I think my point is to say that it's important for us to understand this, to understand that this is enabled by not just the Trump administration, but a movement that began with Reagan, which basically sought to return, right, to a different kind of understanding of what equality meant. The conservative targeting of the judiciary as an important source of power really began then. The transformation of the federal judiciary was an explicit project of the conservative movement, and it matured in terms of the creation of the Federalist Society, the creation of a pipeline for people to enter into the judiciary and ultimately to the Supreme Court. Now, I think it's important not to paint this as a sort of just complete blanket, because as Ahilan just pointed out, there are plenty of judges, included judges reported by Republican presidents, who are saying, this is insane, right? This is wrong. So it's not to say that everybody that's been appointed has sort of been of a particular ideological mode, but the targeting and the particular shaping of the Supreme Court has been, right? That has been completely vetted to the point of ensuring that this is a court that will ratify, that will use law to ratify lawlessness. And that is essentially, I think, another feature, actually, of fascism. So this is not a sunny story, but this is one which I think is important for us to understand, because I think one of the things, I'm sorry that our colleague couldn't be here because she's so eloquent about this question of education, Professor Baldwin Clark. When we think about why, for example, and I really applaud all of you for both being here and for not being afraid to be in a room where the words critical race theory are being spoken, are not, or maybe you are, but you're here. You know what I'm saying? You're here. And for being willing to actually, not that you have to necessarily believe everything anybody says that claims to be a critical race theorist, but being willing to actually engage in the project at a time when it is under such assault, right? What does it mean, and why is it under such assault? One of the things I want to offer, because I really do want to hear from all of you, is oftentimes I've had, and I think I had way years ago, back in the 1800s when I was a student, I can remember a certain kind of frustration with law school as not being engaged in real life struggle and work. Feeling like I was sitting here deep in this, and if somebody talking to me about theory, I didn't want to hear it. I wanted to know what could be done right now. I am sympathetic to that. I feel that to this day, in some respects, that tension. But I want to offer a somewhat different window on this, which is that the assault on critical race theory was the tip of the spear in terms of the attack on democracy itself. Many of our allies at the beginning thought this was a kind of a problem, the racial exception, if you will, right? That they were lamenting the ways in which our body of work and we were being assaulted, but they felt like that's over there, but now we see it was actually the tip of the spear. It was the way in which it actually becomes an attack on democratic ideals more broadly. This is this erosion that I'm talking about. The second thing is that the fact that we call something theory often causes people to turn off and to say this is not really important. But if we think about the way that and what the attack on critical race theory has done, we see actually how important theory really is, right? They didn't start out going after DEI. They started going after theory. Why? Not because theory is magical, but because they understand it's foundational, right? It's foundational. What they are promoting is a particular theory of race, right? They are promoting a colorblind theory of race. It is demonstrably false. Nonetheless, it is a theory. And it takes a better theory to beat a theory, right? But the reason I mention that is to not shy away from claiming your right to theory, okay? And your right to be able to theorize together. Theory is not something that's done in a library. It's actually done, being in a library is part of it, but theory is actually trying to learn the lessons from the moment, trying to learn what it is that the moment is teaching us about how we might move forward. So with that, I want to hear from you guys, but I really do appreciate you all being here.
That was fabulous. I learned so much. I think we all did, and we're very grateful to you both for sharing not only your expertise, but also your humanity and your ability to sort of put what's often very technical knowledge in this broader frame of humanity and our shared struggle. So thank you so much. I think just pointing out that, I think that's a model for how to engage with this material. So I think I'll just ask two questions quickly, and then you can respond as you see fit before we open up to a broader conversation. For Professor Harris, I'm wonder what's new about American fascism. What is new about this moment of American fascism? Because as I'm hearing you speak, I hear my historian is struggling and sometimes convinced that there's a ton that's new, and sometimes convinced that this is all recapitulation. So what's new about this moment?
I feel like I should ask you, Alexander, because you're the historian. But I think there is always something new because the conditions are not identical, right? So the conditions for fascism in Italy were not the same as the conditions for fascism in Germany, even though those things were sort of evolving at the same time, nor were they the same as the conditions for fascistic tendencies in the United States. I don't know that I would describe, with respect to certain aspects of life in the United States, I would say that in the 1930s there were 20s and 30s, there were aspects of fascism. I don't know that I would say that the government itself was fascistic. So I do think it's important to recognize that there are differences now in this moment. I think one of the ways that I'm viewing this as a circumstance where the neoliberal consensus has crumbled, right? It's crumbled for a number of reasons. This sort of neoliberal consensus that's represented in the affirmative action cases that says, you know, racial diversity is okay as long as it's serving a business interest or it's serving the interests of the military. That kind of neoliberal consensus is, I think, it's dying if it's not completely dead. And the question is, why is that? You know, that's what I think, you know, the role of contemporary historians can help us understand, and maybe it even won't become clear until years hence, as frequently it is the case, because history in the moment is often the hardest to figure out. But I do think this way in which the racial project of suppression has ramped up with respect to immigration is not new, certainly not a new feature of fascism, but is such a central part of this particular moment. What Ahilan was pointing out with this shadow docket business is it's also the way in which the government is abusing the emergency docket. Everything's emergency. The birthright citizenship case is an emergency. Why? Why is that an emergency? I mean, it's so hard to think about anyway, but I'm saying just even at the procedural level, why is it an emergency that we overturn this provision of the 14th Amendment right now, right? So I say that to say that I think that there are going to be moments in which we can see some very clear differences, as always, right? National forms of organization of power are going to differ, but I do think there is enough here, at least for me, to comfortably use that word, or uncomfortably use that word.
Thank you. Thank you.
Can I just pick up on one thing you said now, which is so interesting? In the briefing on this question of why the government is entitled to emergency relief, the government is consistently saying just now, just in the Trump 2 era, that when the executive branch does not get to implement the policy that it wants to implement on immigration, I know they're saying this in other cases too, I don't know it super well, but that itself justifies emergency relief. And we're having this kind of doctrinal fight about this in cases. There's a line in CASA, the birthright case, which kind of hints at that, but maybe it's only about the scope of relief, and very technical kind of fight over this. I was literally just briefing this last night and early this morning in the Venezuela case, because it's a great example of this. The appellate process is still going. The argument's coming in just a couple months. The government hasn't said that there's some huge harm that's coming from allowing these Venezuelans who have very high labor force participation rates and have by definition have no criminal history to remain in the country for a few months longer, right? But their position is, if we don't get to do what we want, that is an emergency. And until you said it now, I had not thought about the connection between that and fascist ideology, or these extreme forms of authoritarianism, right? But if you say, if the president, the executive, can't get to do what we want, that needs to be fixed right now, and we can't wait for normal appellate process. That's a very kind of fascist, proto-fascist kind of thing to say, and that is their position in all of these cases. And the court is clearly buying it. They're not explaining why, but they're clearly buying it in a bunch of them because they're granting emergency relief in all these cases.
They're not saying go back and let's wait till the appellate process works out. They're just sort of accepting it as a given, and as you point out in this shadow docket business, they're not even saying why. Yeah.
I would suggest that certainly the authoritarian claim to be able to not only use but base its authority on the ability to state the exception, it has deep roots. And so whether consciously or unconsciously, and I think there's probably a bit of both, I think the current regime knows what it's doing. And if it doesn't know, it's recapitulating old arguments. In terms of what's new, I think that will be a longer conversation, but one thing I think we'll all have to be on the lookout is not only what the moves are, but what the counter moves are, right? Because what happens in the world is going to be a process of push and pull. And so it's not only what authoritarians do, but how other parts of society respond that will determine the outcome. And that's true both in the past, I think, and in the present. Quickly, just a question for on the immigration. So I think I was teaching Fed courts in this room when the Abrego Garcia push and pull was happening, and was assigning some of the opinions as they came out with some of you who were here. And I think it's interesting to think about this moment versus that moment. I think one thing that is clear is that the state of play is a little bit more clear. And one of the things that seems to define the state of play is that there's a push and pull, and some might say a real struggle between at least some, but lots of district courts and even circuit courts and the Supreme Court. And I wonder, asking you, who's involved in this litigation, has this disclosed strategies about how to litigate, particularly at the district court level? Are there opportunities at the district court that you think are worth pursuing that maybe we haven't before?
Yeah, for sure. It's not. It's a bleak landscape, but it is definitely not one where you can say, "Oh, well, there's no point in doing litigation." Just in the last couple of weeks, just our center has gotten out something like 15, 16 people, Venezuelan refugees who were being unlawfully detained. The reason we were able to do that was because the district court in our case, the one who wrote the opinion that cited Korematsu that I was mentioning, well, we proceeded with the case and we won a summary judgment order. And I don't know how many of you have had CivPro and are going to be able to follow all this, or your Fed courts, but once you win the summary judgment order, that wipes out the preliminary relief and the Supreme Court stay order goes away. And so we were able to reinstate all the protection for, obviously many people had lost their jobs and plenty had been detained and deported in the interim between May, when that order, when the Supreme Court order came down, and when we won this order now a month ago. But as a result, then all the people who are still, could benefit from it have their protection reinstated, and then we've been using that to get all these people out of detention all around the country. And the government is saying, like, hey, this is ridiculous. The Supreme Court already said this should be stayed. But what we said was, well, but they didn't say why, and all they stayed was a preliminary relief order, and you can't say that governs this because there's no reasons in it. And law requires reasons, otherwise, if there's no reasons, then there's no precedent. And the district court brought that, and the circuit court bought that. Now they've gone back to the Supreme Court, and I think we have this case, which is, we just filed our brief today, and I assume there will be a decision soon, is actually the first one on a summary judgment, as opposed to being on some form of preliminary relief that's back up there on the shadow docket amongst all these immigration cases. And I think it's one of the first in any of the cases, actually. So that's definitely a strategy. It's forcing them into reason giving. I actually think it's also useful, even when all that criticism is probably what caused Kavanaugh to write his opinion. Then you get all these people looking at this opinion, it's an abomination, and saying, pointing out, doing what Professor Harris is doing, pointing out this is an insane inconsistency, how can you possibly defend this? And then that subjects them to criticism, which makes it harder for them to keep doing what they're doing. So yeah, definitely I think there are. What's hard is big class litigation against, it's all hard, but what's very, very hard, virtually impossible at this point, is big class litigation against blatantly unlawful actions, which is unfortunate. That's a lot of us, including me, spent years doing that, and now that seems to be virtually foreclosed.
Yeah. Thank you so much. I think we have time. Let's group 2 or 3 questions, and then give the panel the opportunity to respond, and with the hope being that these conversations continue after. Yes, in the green.
Yes. Hi, thank you both so much for being here. It's been incredible information. I was wondering your thoughts on, especially with that poem, it just made me think of how everything is so normalized. Every new decision comes down, and there's kind of this mentality of, oh, well, that makes sense because they've done X, Y, and Z. And so, how do you both suggest navigating that climate, and what do you think the role of things like protesting is currently, especially for us as students who spend most of our time, at least me, in the library, versus getting out there and doing the work to the extent we can.
Thank you, and we'll take one more. Yes?
Hi there. Thank you all for being here and speaking to us. Is there any real remedy at the immigration courts directly, for orders of supervision releases, custody redeterminations? How has the immigration courts been impacted? Is all the relief really available at the district and appeals court level? And what does that say about the immigration court process?
Maybe let's take one more and just put it in the stew. Okay, one more question, if there is one. Yes?
What can we as law students do to prepare for an existential fight?
Okay.
In 3 minutes or less, right?
Cold call.
Normalizing obscenities, okay. I think maybe the best way is to, as I suggested, or was trying to suggest, is to recognize the arc of what we're in, not just the not just the thing today, but the arc in which we're in. And that probably is not going to satisfy you, because it's going to lead me to say something about the bifurcation that I just heard you make between protests and what you're doing here. Your presence here is a product of protest, and your everyday presence here and your ability to engage with each other and think together is itself an act of protest. It's an act of protest against the very regime that we're just talking about. That doesn't mean that it's the only form of protest that one can engage in, but I want to actually just resist the idea that it is not, and I'm sure maybe some of you feel like that in class, that you're in some kind of situation sometimes where your viewpoints or your thoughts are not necessarily on the table, right? But it doesn't mean that that act is trivial or is unrelated to other forms of protest that one might be engaged in or one might see. So I don't know that that's an answer that will make you always feel happy when you're sitting in a library, but understand that movements are built on practice, and successful movements are built on theory. Not on theory as the way that leads to practice, but rather understanding what works, what fails, what works, what fails, what works, what fails, and the cumulative lessons that come from that. The last question about what can we do, I think community now is more important than ever, and I don't just mean online. I mean, we have to show up for each other, literally, right? People are suffering. People are facing very, very deep challenges at this point. And we are not going to be in a position, I think, to rely on just traditional politics or traditional mechanisms of care. So I think that, and I'm one of these people that has I get a little allergy when people talk about self-care a little bit sometimes. Not because I'm against self-care, but because there's a certain kind of way in which I think it's sometimes presented. But I do mean self-care to include not just yourself, but the care of the people that you are engaged with. The second thing I would say is the inculcation of allies. Allies do not have to agree with you on everything.
Yes.
And I'll leave it at that.
And I know we're out of time, so I'll just say very briefly that it's true that immigration judges are compromised in a huge way. It's not that there's no relief being granted, no bonds being given, but it's a striking moment when you can look and see the structural difference between federal court and immigration court, because the administration fired and pressured a whole bunch of immigration judges to get out because, of course, they can, and immigration lawyers are really having to learn habeas practice. That is how to get relief for your client in federal court more in this moment than they ever have, at least during my practice years. So I co-sign everything that Professor Harris said about the importance of study and the need to view what you're doing here as a form of resistance and building community at the same time. Could not agree with you more.
These conversations have not always been accessible to many. And in order to keep them open and moving requires all of us to participate very actively. So I'm really glad that you all did that today and look forward to the future conversations. Please give a round of applause.